violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11 in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court, is that correct?
Yes, Your Honor. The court had previously, when we were here before, advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Ms. Red, as his case here.
Mm-hmm.
We had discussed 6, and the court did not feel comfortable with that, so we just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct?
Correct.
Against the same victim.
Correct.
All right. Mr. Lewis, you may proceed.
Judge, in this situation, in all my conversations with Mr. Antoine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues took over where he became in a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All of his family is there. Where he has some sort of support system. And I believe he even talked about that he thought someone was trying to kill him here, which goes to the mental health issues and things that he was dealing with and had, especially during that time. His support system is still there in Louisiana, not including the alleged victim that was on the
Not alleged victim.
Well, I know he played too, Judge. But it's there, but she's not included in that support system. I mean, the rest of his family is there. He does not have any type of family support system here within Jefferson County. So, but I think since he's been in custody this time and understanding that he will continue to have issues if he don't take care of any of the mental health issues that he has. I don't see, just from my communication with him, what I've seen, any substance abuse issues, but mainly it's just been the mental health side of getting that children documented and diagnosed and get whatever treatment in place that's needed. I think if that's taken care of first, then of course I think especially the technical violations, he will be able to handle. The new law violation, he did plead guilty to it. He did serve his time on that case. As well, he has been in custody here since this revocation. It's not like he's been at home. He has been being punished or serving time during this time here, Judge. We are asking that he is allowed to be evaluated for his mental health caseload, whether through SAP or some other vehicle that probation may have that would help him get a grip on that, and that would of course help him get some stability for getting any of the benefits or anything that may be available through Spindletop and MHMR. Of course, it would be a big ask, but we would be asking that if that is allowed, that he does be allowed to transfer to Lake Charles where his family is, so he can have that support system. But even with getting that help, mental health help, he still will need some additional help and encouragement to get through this. But Judge, he understands that he did mess up. He understands that, he hasn't done what he needed to on probation. He's taken account for it, and he's just at this point just asking for any consideration possible for it so he can get some help.
Thank you, Mr. Lewis. Ms. Malfino?
Judge, I don't have anything additional to my initial comments unless Ms. Warrior.
So, do you have anything? I mean, I have your updated report. Is there anything else that you wanted to add that's not in that report?
No.
So I'm looking back, Mr. Antoine, at that original pre-sentence report when we put you on probation the first time. That was an agreed probation. That at this point seems It was a 5/5 probation. Is that correct? Am I looking at that correct? Is that?
I have it deferred for 10, Judge.
So maybe at sentencing that got changed. I'm looking at that old pre-sentence report, and that confused me somewhat because I'm going to make sure. I thought this was deferred. The motion was filed as a deferred, but I want to go back and double check because the cover page of the old pre-sentence report. No, it's a judgment of deferred.
That's what the order says. I think you.
That was just a mistake. Either I changed it or it was a mistake on the thing. Okay, so on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, it specifically ordered all the things that Mr. Lewis is asking for now. You've already had access to all of those things. To be placed on the specialized mental health caseload, to get an evaluation and get any type of help and treatment that is available. You were ordered to do those things. And in fact, what you pled to on this motion, true, is that you didn't get the evaluation completed, and so you never were able to get services, and that was your choice. Everything was given to you. You had all the opportunities in the world to get whatever help you needed so that you could be successful. But the fact that you're on probation, I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her. I mean, it's just, beyond me. That's where what you would do. I mean, it sounds like you go to Louisiana, if you have support, that's great. But to go back and do that to her without permission, you weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on people that you supposedly care about. Got a new offense over there for that. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I believe the initial was, yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
There is
Okay.
a condition one that gonna handle in this minute.
Okay, so you'll abandon that in this motion?
Yes, sir.
Good morning. Are you Brianna Williams? And will your client, well, Ms. Williams, before I go any further, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Williams, in cause number 18-30512, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 20th of 2019 for the offense of injury to a child, and that was a 10-year deferred probation. Is that correct? Count 2 alleges that you provided a urine sample November 19th, 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? And count 3 alleges that you were at a location other than your residence at approximately 11:53 p.m. on November 11th of 2024. And is that true or not true? And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily? And because they're actually true. I have some documents here on the computer that you've signed with Mr. Parker. Did he go over these before you signed them? And you understand if I go along with this and continue you on probation, you won't have any right to appeal. And it looks like what the agreement is for me to continue you on probation, order that you do the 30-day program at the Franklin House. You will be, my computer's stuck. There we go. In addition, you'll be on the high-risk caseload through MHMR, which will give you all the tools, hopefully, that you need in order to be successful and make better decisions. Do you understand? I want you to know that if I go along with this and give you the opportunity, it sounds like probation, everybody wants to work with you, you need to do everything you're supposed to, because if you're back in here again, you probably will not get this same opportunity, okay? So I'm going to find state tenders number 1.
No objection.
It's admitted. Any evidence Ms. Williams isn't competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the agreement, continue you on probation. I'm going to order that you enter and successfully complete the 30 days at the Franklin House. You will be on the high needs caseload so that you can get any help you need and follow all of the rules and conditions of probation. You cannot use marijuana. You cannot be out of your house. You need to do everything you're supposed to, okay? This is your second chance or third chance. It's time to make sure you do everything correct, okay?
Your Honor, I'd like to represent the court. She has done all her classes where she can become a pipe fitter or some other jobs that pay good, and she's actually requested that she needs some type of therapy, which I think MHMR will help. And so she requested that on her own, and she's wanting that.
Well,
So I
and
think
that's
she
when
has a
it's going to work.
positive
Yeah, that's when it's going to work the best, is when you know you need some help getting through some things. Take advantage of the help. You're going to get it, and that way you can go on with your life, hopefully get that great job, and this will all be behind you.
attitude. If you need help, ask the probation. Don't be scared of them.
Yeah, don't be scared. They're there to help you. Ask ahead of time. Don't ask for permission. Don't ask for forgiveness. Does that make sense? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you.
Just a reminder of the court, you might want to remind Mr. Millhouse about the court order regarding the photo.
Oh,
A courtroom hearing took a dramatic turn as Judge Raquel West weighed second chances against repeated failures to follow the law. One defendant, already on probation for a violent aggravated assault involving a family member, admitted to multiple violations, including failing to complete court-ordered treatment and committing a new domestic violence offense against the same victim. Despite arguments that mental health struggles contributed to his behavior, the judge pointed out that every resource and opportunity for help had already been provided. Concluding that those chances had been ignored, she revoked probation and imposed a 15-year prison sentence. In contrast, another defendant facing probation violations for an injury to a child case received a different outcome. After admitting to drug use, curfew violations, and unpaid fees, she showed a willingness to seek treatment and improve her life. The court acknowledged her progress, including job training and efforts to obtain counseling, and granted another opportunity through intensive supervision and rehabilitation programs instead of prison. The hearing highlighted a powerful message often seen in Judge West's courtroom: accountability matters, but so does the willingness to change. When defendants embrace the help offered, the court may extend mercy. But when repeated opportunities are ignored and the same harmful behavior continues, consequences become unavoidable. In the end, The difference between freedom and prison often comes down to one simple question. What do you do with the second chance you're given?